Red and blue lights fill your mirror. You pull over, hands on the wheel, doing everything right. The officer leans down and says a sentence built to bypass your brain entirely. Pop the trunk, or you are going to jail. Your instinct screams, open it, comply, make this go away. That instinct is exactly what gets people convicted. And after reviewing dozens of body camera videos of this exact demand, I have watched it happen on tape more times than I can count. The trunk is the single most contested space in your entire car, more constitutionally protected than the seat you are sitting in right now, and the jail threat you just heard is, in most circumstances, legally false. I have spent this research pass studying the case law behind that exact sentence, the Supreme Court rulings that expose it as a bluff, and the one word, just one, a driver can say before doing anything else. A word that forces the officer to either produce real legal authority or admit on the record he does not have it. Say it first, and every single thing that happens after it changes completely, on the record, in front of a camera, that cannot be argued with later. The trunk is not the cabin. Here is the legal reality most drivers never learn. Courts already treat certain spaces as so private that officers need overwhelming justification before entering them. In Florida versus Jardines, the Supreme Court ruled that a home's front porch, the curtilage immediately surrounding it, deserves the same protection as the home itself, and officers cannot invade it to gather evidence without a warrant. Your trunk is not your home, and vehicles do carry a lower baseline of privacy than houses under decades of precedent. But within that lower baseline, the trunk still functions as the vehicle's own curtilage, the sealed compartment furthest from anything an officer can see, smell, or reach during a normal stop. Unlike the front seat, the dashboard, or a cup holder sitting in plain view for anyone to notice under the plain view doctrine. That is exactly why officers target it, and exactly why the demand to open it carries more legal weight than almost anything else said during the encounter. Every other part of this stop is negotiable through conversation, tone, and cooperation. The trunk is not. What happens in the instant that demand is made determines what a judge sees months later on a suppression motion, and that instant starts with what you say first, before you touch the release lever, before you say a single unnecessary word to fill the silence, because silence, used correctly, costs you nothing at all. The jail threat is a bluff. Now let's expose the second half of that sentence: pop the trunk or go to jail. Officers are trained to pair a demand with a consequence, because fear collapses rational thought faster than any legal argument ever could. And a scared driver rarely stops to ask whether the threat is even legally real. Here is what they are not telling you. In the overwhelming majority of states, refusing to open your trunk is not, by itself, a crime. Obstruction statutes require you to physically interfere with or actively deceive an officer's lawful duties, not simply decline a request. Speech alone, including a calm refusal, does not meet that bar in most jurisdictions, and appellate courts across the country have overturned obstruction convictions built on nothing more than a driver declining a search. Where obstruction charges do exist for pure refusal, they are typically classified as a low-level misdemeanor carrying, at most, a matter of months, nowhere near the open-ended jail threat implied roadside. Stay calm, stay polite, but stay firm here, because your tone matters just as much as the word itself. So when jail gets attached to a request, you are legally allowed to refuse. That is not a legal consequence. That is a pressure tactic dressed up as one. Police are permitted to lie about evidence, witnesses, and what happens next. And courts have upheld that deception as legal strategy. What they cannot do is manufacture a crime out of your silence, your refusal, or your calm no. What the Constitution actually requires. That bluff only works because most drivers do not know what the law demands before a trunk gets opened. Under United States versus Ross, the Supreme Court held that officers may search a vehicle, including its trunk and every closed container inside it, without a warrant if they have genuine probable cause that it contains contraband. California versus Acevedo later confirmed that same reach extends to any closed container found during that search, provided the underlying probable cause attaches to the vehicle itself, not just to a bag someone happened to carry inside it. That is a real, binding legal standard, and it sits far above a hunch, a feeling, or a threat shouted through a window. Probable cause means specific, articulable facts, not simply an officer announcing that he is allowed to do this. Here is the gap officers hope you never notice. If they already had that probable cause, they would not need to threaten you into compliance. They would simply search, because Ross already grants them that authority without asking permission at all. The jail threat is a substitute for probable cause they do not actually have. And under Bumper versus North Carolina, the Supreme Court ruled that when an officer asserts authority he does not actually possess, and a person submits because of it, that submission is not voluntary consent. It is coerced acquiescence, and evidence gathered that way can be suppressed entirely, regardless of how calmly or politely the trunk was eventually opened by a frightened driver. The word. So here is the word. Not a sentence, not an argument, one word, spoken calmly the instant you hear pop the trunk or go to jail. Warrant. Said as a question, nothing attached to it, nothing explained. Compare it to the 4 things drivers actually do instead, because every one of them is legally weaker, and none of them survive a suppression hearing as well as this word does. Compliance, simply opening the trunk, gets treated by courts as full consent, and consent cures almost everything, waiving your right to challenge whatever they find inside. A full sentence refusal, such as "I do not consent to this search," is legally correct, but arrives after the officer has already put his authority on the record unchallenged, and now you are relying on a judge believing your account of tone and timing months later. An explanation, such as "there is nothing back there," hands the officer new information and invites follow-up questions that build his case against you. Negotiation, such as asking if there is another way to handle this, reads in a courtroom as willingness to bargain, which prosecutors frame as partial consent. The one word does none of that. It does not concede, it does not argue late, it does not inform, and it does not bargain. It simply forces the claim of authority to be tested immediately, on his own body camera, in his own recorded words. Why the full sentence fails. Watch how this actually plays out, because the difference is not subtle once you hear it side by side. The officer says, "Pop the trunk or you're going to jail. Your choice." The driver answers, "I do not consent to searches." The officer pushes back, "That's not what I asked you, ma'am. Step back, please." Notice how the officer simply redirected around the sentence entirely, because a declarative statement invites a counter-argument. And counter-arguments are exactly what officers are trained to win on the roadside. Now hear the one-word version. The officer says, "Pop the trunk or you're going to jail." The driver responds with a single word, "Warrant." The officer answers, "I don't need one. I have my reasons." The driver says, "Then state those specific facts for the record, because I have not consented to anything, and I am not opening this trunk voluntarily." The second exchange sounds like a citizen calmly making an officer produce his authority instead of arguing with him, and courts weigh that distinction heavily when they review body camera footage later. In City of Topeka versus Murdoch, the precise wording a person used the instant police asked to enter became the deciding factor in whether consent was ever legally valid at all. And that same first-word scrutiny gets applied directly to trunk demands during traffic stops. And if legal breakdowns like this are new information for you, subscribe right now so you catch every one of these before your next stop. Because what happens after the word changes absolutely everything that follows. The fork you create. Once you have said it calmly, without raising your voice, the officer's options narrow to exactly 2 lawful paths, and there is no quiet third option where the jail threat gradually becomes real. Path 1, he states actual probable cause on the record, specific facts, not a threat, and proceeds under Ross with real legal footing behind him. Path 2, he cannot articulate probable cause, and legally, the trunk stays closed unless he obtains a warrant or you freely consent, which, staying calm, you are simply not going to do. This holds whether the stop is still a routine traffic encounter, has become a Terry-style detention, or has escalated toward arrest because probable cause for the trunk is judged on its own, separate from whatever justified pulling you over in the first place. Here is a documented pattern built from realistic composite facts drawn from suppression hearings across multiple states, clearly hypothetical, but grounded in how these motions actually resolve in court. A driver asks the one word. The officer, unable to cite specific facts, shifts his footing and says, "Well, I'll just get a warrant then." Under bumper, that shift is itself powerful evidence the earlier jail threat was never backed by real authority in the first place. If the officer searches anyway without ever answering the question, stay calm, do not physically resist, keep your hands visible, and say clearly, "I do not consent to this search, I am complying under protest." That sentence, paired with the earlier one word, builds a suppression record that is very difficult for a prosecutor to overcome, because every recorded second shows escalating pressure with no legal justification ever produced on camera. State lines, same word. Before we close, understand this differs by state, and verifying your own state matters more than any single video ever could. Everything just covered is your federal baseline, but some states layer on more protection and others add procedure on top of it. In New Jersey, the state Supreme Court ruled this year, in State v. Fenimore, that its own automobile exception is narrower than the federal one, requiring genuinely unforeseeable, spontaneous circumstances, not probable cause alone, which makes the word even more powerful there. In Ohio, the state Supreme Court's own ruling on remand in Robinette gave drivers constitutional protections beyond what the federal case allowed, even though the United States Supreme Court said officers never have to tell you that you are free to leave. In Illinois, state police directives actually require officers to use a written consent form before a consent search is considered proper procedure, meaning a mumbled "okay" roadside falls short of the department's own internal standard. In states without those extra layers, the federal Ross standard is the entire ballgame, so the one word matters even more there. None of this changes overnight, but rulings like Fenimore show this area of law is still actively moving. Verify your specific state's current rule with a licensed attorney before relying on any of this roadside. Core principle and closing. Here is the core principle to keep above everything else in this video. When an officer pairs a demand with a threat instead of a fact, your job is not to argue, it is to stay calm and make him produce the fact, starting with one word: warrant. Keep your hands visible on the wheel, do not reach for anything until asked, and do not open that trunk yourself just to be helpful. Keep these 4 phrases ready for any stop, printed, memorized, in your glove box tonight. Am I free to leave? I invoke my right to remain silent. I want an attorney? I do not consent to any searches. This is educational content based on case law research, not legal advice for your specific situation. Always consult a licensed attorney in your state before you rely on any of it for a real encounter. If this gave you something you did not have 5 minutes ago, subscribe so this reaches you before your next stop. Like this video, tap the bell, and share it with someone who drives regularly. Drop a comment telling me what state you are in and whether an officer has ever demanded your trunk without stating why. If this belongs in front of more drivers, hype it right now. That is how it reaches the person who needs it before their next red and blue light. One word does not just open a trunk, said first and said calmly. It can close a case before it ever really starts, long before any judge ever sees the file.